morning, guys. Welcome back to another edition of TLG Live. I am Jonathan Nieh, one of the founding partners at Trowbridge Law Group, and today I'm talking about no action letters and why they're important. So, what is a no action letter? A no action letter basically is a letter from the SEC that they issue in response to another letter from an issuer, basically saying that they're not going to take action against the issuer based on certain facts, certain reasons. So usually, how it works is the issuer will um, hire a law firm. These things cost a lot of money, oftentimes. So it's usually big law firm that issue these things. So the issuer will hire a law firm to draft a letter to the SEC, basically detailing out all the steps that the issuer is taking or is going to take, and then all of the reasons and all of the case law, all of the statute, basis for their reasoning why they think this is legal and the SEC should not take action against them. The SEC will read the letter and either issue a response or won't, basically saying, well, the goal is to get the SEC to issue a letter that says, we will not take action against you. We'll take no action against you. So, this is a great tool for not only the issuer that is, drafting the letter, because they get basically a piece of paper that says, what we're doing is legal and we're totally in the clear, but it's a great tool for other issuers too, to, read these no action letters to get a sense of, if we kind of copy these other companies and we have similar processes to these companies, we'll be okay too. So it's not the exclusive tool that you should rely on if you're an issuer, right? There's other, case law. The SEC puts out compliance and disclosure interpretations. That's another great tool to work or to use when you're, trying to figure out what you're doing is right or wrong. So it is one tool, but it's not the only tool. And one of the issues with no action letters is each letter is very specific to that company's facts, right? So if you deviate from those facts, then that letter is not going to apply to you anymore. And I think the most effective way I could highlight that is the fact that we have these myths in our industry, right? So one of the biggest myths out there is that there's this 30-day waiting period to establish a pre-existing relationship, right? So some people out there think that, if you meet an investor and wait 30 days, you'll be in the clear because you've established a pre-existing relationship. And where that myth comes from is actually a no action letter, right? So it's a pretty famous one called LAMP Technologies. And yes, in that letter, LAMP Technologies did wait 30 days before meeting an investor and taking their investment. But if you read the letter, there's a ton of other things that the company was doing to establish that substantive and pre-existing relationship. So, if you just read that one part where it says 30 days and you just do that, there's no guarantee that the SEC is going to not take enforcement against you because you missed the rest of it, right? So that's important to keep in mind when you're reading these no action letters is, it's very fact based and it's very specific to that company's individual circumstances. So yeah, I mean, if you have questions about particular no action letters, number one, first thing you should do is contact a law firm, right? Get their opinion. Our firm, we read these all the time, so we're happy to talk to our clients about our interpretation of these letters and what they should and should be doing. Anyways, that's about it for you guys this week. It is Thursday. That means there's a new episode of TLG Talks. This week, Gene is interviewing Andrew Cushman. Yes. Okay, great. Great episode. Longtime client of ours. So tune in today at noon at our YouTube page. Yeah, as always, thank you for tuning in, and I'll see you guys next week.